Call the second case on this morning's docket, 103020 Busman versus Safeco Insurance Company.
Good morning. I'm Paul Hasty here on behalf of I think we're the appellee and cross appellant. We're the petitioner on the petition for review, and I'd like to reserve 5 minutes for rebuttal, if I may.
All right, thank you, Mr. Hayes.
We see there are 4 issues here. The accident, as you know, occurred when Ms. Busman was involved in a motor vehicle accident in the state of Oklahoma when she was hit by a vehicle that either made a left turn or went left of center. She sued Safeco Insurance Company of America, who is the liability insurance carrier for the tortfeasor. She claimed underinsured motorist benefits. Safeco paid the policy limits on behalf of the other driver and took a release. Plaintiff then sued that insurance company, claiming underinsured motorist benefits. She said, under a policy issued to the bank that employed her and owned the vehicle she was operating at the time the accident occurred. Safeco admitted in the answer that it insured the tortfeasor, denied that plaintiff had a direct cause of action against us. The case proceeded through discovery. On the morning of trial, plaintiff offered into evidence or asked the defendant to stipulate to the American States or American Economy policy on the bank, and defendant said it's not relevant. There's no claim on that policy. The court allowed it, and the case proceeded to trial, and there was a verdict, as you know. The Court of Appeals held that the issue was waived by not being asserted in the pretrial order. Plaintiff's position seemed to be that the identity of the defendant and proving coverage under the policy is an affirmative defense, and we deny that. We think that's wrong. It is always plaintiff's burden to prove the policy and to prove coverage under the policy. Those things were denied in the answer. They were denied in the pretrial order. The court held that because...
How do we tell? I mean, do we even know today whether it's American Economy, American States, or Safeco Insurance Company of America? I mean, when you look at the policy, you're really difficult to tell who's covering or providing which coverage.
You have to read it. That you're exactly right, sir. That is true. Allstate is a trade name.
Well, I understand that argument, but
All right.
but do we have any definitive proof in the record before us that Safeco is Insurance Company of America is not providing this coverage?
Yes, you have the policy.
And the designation on the deck sheet, is that where it is?
You'll find it there, yes.
Because I think we've said in some cases that the deck sheet really isn't the policy.
Well, except it tells which company issued the policy. Yeah, if you just took the policy language itself without the declarations page, there would be you wouldn't know which insurance company was involved, because it says we and you. You means the insured. We means the company issuing the policy, and look at the deck page and it'll tell you who that is. And I think you'll see with comprehensive commercial policies these days, more than one company is in the contract. For instance, American States might issue the contract for liability. American Economy would be the responsible insurance company for physical damage to a vehicle. But Safeco Insurance Company of America isn't in this policy anywhere. It is not.
Let me see if I understood you. So American States had the casualty and American Economy had the property?
That was an example. And I don't know whether I've got them backwards in this case or not. I can't remember. I'd have to look at the policy. I didn't bring it with me.
But there are different companies providing the casualty and the property.
That may happen, absolutely.
But we don't know if it happened here.
I didn't bring the policy, Your Honor, so I can't answer your question specifically.
Well, I think it make a difference, or potentially could, when you're looking at the 4908.
I agree.
It talks about providing policy coverage.
I agree. It could. It could. The other thing that troubles us greatly about the Court of Appeals decision is the court held that the offer of judgment would be used against the defendant to prove coverage. And the statute specifically says no to that one. If an offer of judgment is not accepted, it is withdrawn and can't not be used for any purpose. But that's what the Court of Appeals did. They relied on an offer of judgment. We think it was wrong. We suggest to you that on that first issue, this case should be reversed. There was no evidence presented by plaintiff that plaintiff wasn't insured under a policy of insurance issued by the defendant. Zero. The policy of insurance issued by the defendant was not in evidence. It insured the other driver. So the answer there should be, or the result there should be a reversal and judgment for the defendant. With regard to the second issue, the court instructed the jury that the jury could award damages for future medical expense. There was testimony by Dr. Ketchum that he recommended surgery, and plaintiff testified that she decided not to have the surgery. The downside or the possible consequence she thought was worse than the benefit she would receive, and so the evidence was undisputed. I'm not going to have the surgery. Dr. Ketchum testified, and the Court of Appeals found...
And she didn't get any damages for the one she said she wouldn't do. The jury didn't award any damages for the procedure she declined.
We don't know that.
The numbers match up.
The numbers match up.
Yeah.
Yes, sir. The Court of Appeals found that it was proper for the district court to submit the issue to the jury because future medical was, quote, possible. And we say that is never enough to satisfy a burden of proof of more probable than not. And that's the word the court used, was possible. And that's not enough. This should not have been submitted. The third issue is workers' compensation. Ms. Busman was in the scope and course of her employment at the time the accident occurred. She made a workers' compensation claim. She got an award and went through the appeal process. Her award was reduced, but she has future medical as a workers' compensation benefit. Both the policy and the statute, the mandatory uninsured motorist statute, 40-284, say the same thing. There is no uninsured or underinsured motorist coverage for something payable as a workers' compensation benefit. Period. Future medical for Ms. Busman is payable as a workers' compensation benefit because her future medical was left open. That's statutory. She went through the appeal process, and the decision on appeal says that. So if she has future medical as a result of this accident, some injury caused in it, she has a workers' compensation benefit.
Well, the UIM policy and the statutes speak to, quote, entitled to receive, end
Yes.
quote. Tell me why the ALJ's ruling entitled her to receive.
Because the future medical is left open. If she has future medical for injury caused by this accident, she's covered. She's entitled to receive it. It's the same burden she would have for future medical in a civil case. I'm sorry, ma'am.
What is her burden? Once that she incurs that future medical, does she not still have some burden to show it was causally related to the accident?
Yes.
And so it's not a given.
That's true. It's the same burden she has in a civil case. It has to be causally related to the accident. If it is, then she has workers' compensation benefits. If it's not, she doesn't, and she's not entitled to UIM benefits either.
And do we know, is there also, so that's one contingency, causation. The other is proof of what the actual cost of or the reasonable cost of the exam is. So that there are at least two contingencies so that we don't know exactly what she would receive. Does that matter?
I don't think it matters.
You think just the fact that she's entitled to the future benefit is enough?
Right, whatever the expense is. Yeah, in a civil case, we're guessing. Guessing is probably the wrong word because if it's a guess, it doesn't meet the burden of proof. In a civil case, we are, if there is sufficient evidence, we are making a judgment on what it will be. When there's
You're
workers'
saying
compensation coverage, you don't have to do that because it's not what it will be. Yes, sir.
And you're saying that the only, even though it's an estimate of what will be the future, that if it's not causally related or it isn't a reasonable medical expense, then it wouldn't fit within the judgment here any more than it would fit within the workers' comp. Is that what you're saying?
Yes, sir.
Okay.
The same burden both ways.
The fact that they're coextensive is what wins your argument.
Correct. That's right. The last issue is the attorney's fees issue under 40-908. And we certainly agree that if you take some language out of decisions, out of context and out of the facts of the case, 4908 applies to any policy in the world. That's pretty broad. Any policy that is issued that insures property in the state of Kansas.
No matter how ridiculous it may be, or some of us may think it may be, what we are looking at and what we've been doing recently is using the plain language of the statute, and it's all actions, and in which judgment is rendered against the insurance company on any policy given to insure any property in this state against loss by fire, tornado, lightning, or hail. The court in rendering such judgment shall allow the plaintiff a reasonable sum as an attorney fees for services in such action. And it really doesn't say that the property has to be related.
That's
right. Tell me how you can get there. How can you get in this language, even though we all know that wasn't what it was intended for? We know it's we're on a journey to Ridiculousville, and point of no return was Lee Builders, and I don't know how we can step back from that now, as the Court of Appeals dissent did, and make a policy argument when all the cases to this point have been plain language. You understand what I'm asking?
Yes, I do.
Okay.
Yes, I do, and that is a difficult issue for me. The general language of the statute, you're right, says any claim in all policies.
And it wasn't changed after Lee Builders. It wasn't changed after the case back. I can't remember the name when they came up with the bad faith, and this court said it didn't supersede 4908, that they applied to property versus casualty and didn't amount to type of loss. It was just the coverage. All of those cases that are leading to where we are today could have prompted the legislature to clean this up, and they haven't.
You're right.
And what do we do about that?
The statute was never intended to do this. That's the best answer I can give you. And you're right, it does lead to Ridiculousville, and the one that comes home to me the closest is, lawyers buy coverage on property because we have some computers in our office. Typically we don't have much property. It doesn't take much property to run a law office. But there's a part of the policy that provides me coverage as the administrator of the 401k plan, if I somehow screw that up. So if an employee sues saying the 401k plan wasn't properly administered and I lost my investment and you're liable because you didn't administer it right, there's attorney's fees if I ever get in a dispute with my insurance company on coverage because I insured my computers if someone stole them. And that is Ridiculousville. I think you're exactly right. Here...
But that's what the plain language of the statute leads us to.
If you look no further than the general words of the statute, I think you can get to that ridiculous result. I really do. Here, Ms. Busman's not even an insured under the property coverage. She's not an insured person there. The bank is, because the bank owned the vehicle. She would be an insured under her own automobile policy if she bought physical damage coverage. And the reason it makes no sense is this. If you have a person who has his own coverage, and he's driving an older car and doesn't buy physical damage coverage, and he makes a UM claim as a result of an accident, he's not entitled to attorney's fees under 908 because he didn't buy physical damage coverage on the car. You take the same person who has a newer car, perhaps he finances it, so he has to buy physical damage coverage. Well, now he gets attorney's fees on the very same claim.
You don't even have to go there. This policy included the bank's building.
True.
And so under the policy, the building was insured for fire. even if it was just a straight fire policy. If you read this, it's in the disjunctive. So if there's any property in this policy, even if it's a package policy, then under the plain language, there's attorney's fees.
That's right. And I don't remember if it covered the real estate or not. Doesn't matter. It covered the car, and there's coverage on the car if it was damaged by hail. So, we can go on and on the different kinds of policies, and we think it just makes no sense at all. This is
Well,
not a
that's
property
why I
damage
asked
case.
you before about the companies, because the statute speaks to coverage, and our cases have talked about, we're talking about coverage, not about type of loss.
That's true.
So does that impact anything, the fact that there was not coverage
Well, here I think
for this plaintiff for fire, tornado, hail, whatever the statute says?
it does here because she wasn't insured under the Safeco Insurance Company of America policy at all.
Well,
But even if she had the right company, no, she's not an insured person.
well,
But the policy does.
But explain to me how we can feed that into 4908, that the coverage, the fire coverage wasn't applicable to her.
Yeah, if I were writing the opinion, I wouldn't do that for this reason. And I'm trying to say this as I should. I think sometimes when a court tries to go too far to justify something, we wind up with bad law. Here, I think the right answer is this statute was never intended to cover anything other than property. This is not a property claim. I think that's the right answer. If the question is, but the broad words of the statute could be interpreted that way. Matter of fact, they say that.
First party property, because, that's the Court of Appeals dissent says, well, we can separate whether it involved property or bodily injury, but it still was a casualty claim in Lee Builders. It wasn't a property claim, it wasn't first party property claim. It was a casualty claim, and typically the insurance business has separated property from casualty being first person, third person.
True.
So I'm asking you what you're asking us to interpret when you say property. Are you talking about first person property or simply that property was damaged instead of a body?
I think the claim has to be property damage, as it was in Lee Builders. I'm not sure. Well, I think I disagree with the court's opinion on the earlier case, and like you, Your Honor, I've forgotten the name of it, but the court held that if it was a property claim, even though it wasn't hail, tornado, wind, lightning, that kind of things, the statute still applies. I don't think it was intended to do that either. And I think the court looked at that and said, well, that's what the legislature said. I don't think it means that. I think it means a property claim. Thank you.
May it please the court. My name is Fred Spigarelli, and I represent Mrs. Busman in this case. God, it's getting old. It started in 2007, so we would like to get this resolved one way or the other. But to start out with, as I understand,
Actually, it started in 2005, didn't it? Wasn't she injured in 2005?
I think the case started, though. Yeah, I think the wreck was even earlier than that. But as I recall...
Tell me why it doesn't make a difference who the actual insurer is here, whether it's Safeco Insurance Company of America or American Economy or American States Insurance Company.
Well...
Why don't you have to sue the company, the actual company that actually issued the policy under which your client's claiming benefits?
Because we believe we did. And if they've muddled that in their policy by putting American States and the other insurance company there, Safeco, American States, and American Economy, But in the Court of Appeals decision, I think, you know, they looked at the policy real closely and said, well, there's even language in there, welcome to Safeco. We hope that, you know, that you'll be happy with our product. But not only that, if you will look into the policy, there's a section on there, whose name will be insured in driving the bank's vehicles, and Mrs. Busman, along with others, are in that.
Well, not really. If you look under the who is insured, you are covered for you for any covered auto. And you is the named insured in the deck, which is the bank, and then the subsection B says anyone else, and then it has some subsections, and one of them is your employee if the covered auto is owned by that employee or a member of his or her household. Now, your client was an employee of the bank, correct?
Correct.
And she didn't own that vehicle, did she?
No.
Did any member of her household own that
No.
vehicle? So that auto isn't covered for her, and she couldn't have collected the money. If the car was injured there or damaged in this wreck, could she get the money?
No, not for the cars. It didn't belong to her.
Well, so she's not covered for the fire, wind, etc. Coverage. She's not covered for that. She's covered for an uninsured motorist claim,
Right.
but she's not covered for the property damaged by fire, tornado, hail, or lightning.
I don't think so, unless the lightning hit the car that she was driving in, but I don't think so, no. But here's the way I see things. You know, the insurance company created this problem. The insurance industry created this problem with this product. You know what would have solved it? What would have solved things if they would have had separate policies, but they want to sell those comprehensive policies. I don't know what's behind it. Maybe it's a marketing tool, but it seems to me that why not just?
I tell you, it's a boon for the insureds because they can get it cheaper. If you buy separate policies, it's going to cost you more than if you bought a package policy. And so if you're advocating for that, you're actually advocating against the public.
Well, I don't know enough about it to really advocate either way, but as to the issue of 908, it seems to me that would have solved their problems. Because if she's driving a car that's owned by the bank with liability and underinsured and PIP on there, this would never come up under the policy that she has nothing to do with. We didn't create that.
It did come up, so let's move on to the future medical, if you would, and tell me why that the language that says entitled to receive does not encompass the workers' compensation award.
Because we got to look at the award, and it says she has a right to future medical treatment, and it will, on proper application, it will be considered. That's not a number in there. That doesn't say anything. That means I lived in these workers' compensation cases forever. That means you got to file another claim. You've got to put on another witness.
Because it's not liquidated, is what you're saying. That the workers' compensation litigation or proceeding did not liquidate an amount is why?
Well, it's impossible to do that. At that time of the award, all they can say is, the evidence shows that you may need another operation. There's two in the record in this case. One was for $15,000 and some, and the other one was $20,000, which you touched on in the other argument. And so she got on the stand and said, I don't want that first one that Dr. Ketchum said, but I'll sure take the other one. So to answer your question, the award just says it will be considered. Well, that's fair. That seems like a reasonable statement. It will be considered. But the ALJ may not say or may not go along with that. Maybe you're too late in time, or maybe we don't believe your doctor. And that's another thing. In workers' compensation, the insurance company picks the physician to do the surgery. What if she finds one? What if the insurance company finds one and says, oh, you've gone this far, you don't need another surgery? So where does it say that the plaintiff has to choose? I don't think it does. She has a right to file a claim in a civil action. She put on evidence. And
Well, where it says is, doesn't the insurance policy say if workers' compensation applies, then we're not going to cover it?
I'm not sure about the word applies, but
Entitled
they
to
get
receive
a
is
set
the
off.
language.
The
Entitled to
UIM carrier
receive.
gets a set off.
Yeah.
And they got a set off, $51,000. And the defense, Safeco, now wants they want to take that offset and apply it for another $20,000, that there's no $20,000 in that award. So, no.
Well, that 51,000 is what was actually paid, and if you're taking only what's paid, then what's paid is not a future medical. Once it's paid, it's no longer a future medical.
No,
and,
but
and so that's not what we're talking about here. We're talking about her I can't recall which one was it. The 20,000 was the one that she didn't say she would take, that they awarded. They awarded 20,000 in future medical. Is that correct?
the jury?
The jury.
Yes.
Yeah.
Yes.
We're talking about that 20,000. So you're saying that the injured person gets to select between workers' comp and underinsured motorist coverage.
Yes, for this reason, in this case. All I know is about this case. She did not get an award in workers' compensation for $20,000 or 20 cents. She didn't get an award for that. It said it will be considered. Well, what does that mean? And that's all it means, is that we may.
But is she entitled to receive in workers' comp?
You mean today?
No, is she entitled to receive that 20,000 in workers' comp, in the workers' comp case?
Well, I don't know. I don't think anybody would know that. That's up to the administrative law judge or the board. So, I mean, it is what it is. I mean, where does it say that she gets any money other than she can apply for it if she needs medical treatment? So, now, one other point on this, whether there was the right or wrong or the appropriate UIM carrier sued, that was never an issue in the pretrial order. It went to trial on a wreck. Basically, what we did is try to wreck as to and the only issues in the case was who's at fault, what percent, and what are the damages. The judge allowed him, when Mr. Hasty says, well, I'm moving right now for a motion to dismiss because they've sued the wrong party. And the judge said, no, we're going to go ahead for a trial. This is all new, but I'll tell you what we'll do. We'll have a trial. You put on your evidence or your motion. He filed his motion. I responded. I gave him the contract of insurance. He decided there was coverage. You know, you justices may be too young, but in the 50s, there was a quiz show called To Tell the Truth. And you'd have 3 contestants, and they'd get up there and start talking about themselves, but 2 were imposters. So at the end of the questioning, they'd say, will the real UIM carrier please stand up in this case? So they got all their names all over this policy. They got the same address and the same people it shows who are the corporate representatives, who they are. It's all the same people. Now, I would have liked to have tried that part of the case. I think we would have been successful. But just on the face of it, the trial judge said, this looks like I could have picked either all three of them or one of them. So, other than that.
Can I ask you about the procedural aspects of that? I understand the pretrial order, that issue was not part of the pretrial order. But explain to me why being the wrong party is an affirmative defense, like under 6212.
You know, I don't know if I said affirmative defense. I don't remember the pleadings, but I did say this. At some point in time, they should have told us before the day of trial that, hey, by the way, we don't need a trial. You sued the wrong party. So that's all I can say.
I was just trying to clarify
Yeah,
how
yeah,
you're
it's
arguing this. I understand your argument. Hey, they didn't put that issue in the pre-trial, and we tried it based on how it was pre-tried. And,
Right.
And
But-
it's too late now. I understand that argument, but there was some talk about affirmative defense, and I want to try to nail down what your argument was as to why that's an affirmative defense.
I don't remember that I said affirmative defense. I just said, isn't this late? But the other thing is, what I thought of, all that was cured. He filed the motion and the court ruled against him. If the judge thought that there was something to this, he probably would have said, well, I'm going to set this aside, or at least hold it in abeyance, and we'll figure out who the right defendant is. That didn't happen. He didn't get past his motion. The judge entered judgment. I think on the face of the policy, what else are you going to put on other than the policy? So,
So how do we consider that? What is our scope of review over that question, given the procedural posture?
well, is there evidence?
We don't treat it as a motion to dismiss review. We would treat it as more like a summary judgment where we consider the evidence.
Very good question. Is there, I guess, wouldn't the substantial evidence rule apply? Is there substantial evidence that when the trial judge made a finding that
So
there was
we
coverage?
treat it almost as if it was a court trial, in your view, on that
Yes.
issue.
I mean, it's weak because it came there, after the trial, and it's a motion, and we responded, and he decided it in our favor, but he had the policy. That's all I know about it. And so, but if you look at the policy, you can't tell who's the insurer on that. Probably all three of them, because they all have the same corporate office. They all have the same people that show who their officers are, CEOs. So I think that probably was a major issue in the court's thinking, the way I read that order. But anything else? I feel like I haven't said enough on this attorney fee business, but I guess that's all I have. Thank you. Thank you, Your Honor.
Thank you, counsel.
Mr. Spigarelli asked a rhetorical question. You know what would have solved this? The answer is, yeah, read the answer. This isn't the first case this court has seen where someone just doesn't read the answer. The answer said, we deny you are uninsured under the policy. We issued the general liability or the auto liability policy to the tortfeasor. We deny you have any direct cause of action against us. All you have to do is read it. And the pretrial order does show that was denied. Plaintiff claimed plaintiff was insured under the policy for UIM benefits, and that was denied. It's in there. The last theory he advanced is really interesting. He said they all have the same corporate officers. That theory is that if John Smith is the president of 4 corporations. All 4 corporations are liable for the breach of contract by one. And there's no legal basis for that at all. There's just none. And, Safeco Insurance Company of America is not mentioned anywhere in that policy. It's not there. There is a trade name, Safeco. That's like a trade name, McDonald's. That doesn't mean McDonald's Corporation is liable for a slip and fall that occurs in a franchisee. Allstate Property and Casualty Company is not liable for breach of contract by Deerbrook. They may have the same corporate officers. Allstate may own Deerbrook Insurance Company. But it's not defendant's burden. It is plaintiff's. And, Your Honor, you asked a question whether the insured has the right to, not the insured, the claimant has the right to select underinsured motorist benefits or workers' compensation benefits. And I think that's, in my view, the wrong question. This plaintiff can get both under his theory. There's no provision in workers' compensation law that would prevent Ms. Busman, if she has future medical, from going right back to the administrative law judge and saying, pay it. There's no exclusion in workers' compensation for something that's paid as an underinsured motorist benefit. There is an underinsured motorist law in the statute. That's why it's there, so you can't get both. But that's the way it's set up right now. And I agree with Mr. Spigarelli on one thing. Right now, there is no number for future medical on her workers' compensation claim because she hasn't had any. And once she has it, there will be. If it is caused by, that's the causation argument. If it was an injury in the accident and the medical is necessary, then it's there regardless of the number. Could be $1, could be $1 million. Whatever care it is there. It won't be speculative at this point. Here, it was speculative because the doctor said or the Court of Appeals said it was possible. That was their word, it was possible. But even if you had evidence, more probable than not, that there was going to be future medical, and the jury could then put a number on it, it's still the same thing as workers' compensation, except it's not a definite number. There's nothing in the law that says that there's UIM coverage for future medical or anything paid by workers' compensation until it is a number. And this case is a good example because this lawsuit was filed before the work comp case was resolved. What happens if this one gets tried first? Then the theory that they're advancing is that it all is a UIM benefit, and then they can prosecute the work comp claim.
Do you
We say that
think
makes
you
no
would
sense.
have a future action for set-off in that case? If you were first, judgment was entered in the civil case, and then there's a work comp, could you seek a set-off?
I think, well, I thought I understood your question until you said set off, Your Honor. Would we have a claim? No, I assume we'd pay it. Assuming we're on appeal, it'd be done. Then could we sue to get it back? I don't know how that would happen. We know that if the company pays PIP and it should have paid work comp, you can't sue to get that back. We have that case. So I think you probably can't. I don't know of a case that's ever tested that one. Thank you.
Any questions? Thank you. Court will take this matter under advisement, and the court